Hello. Have you ever wondered what your rights are pertaining to the Fourth Amendment and privacy concerns? Well, my name is Zachary Reed, and today I plan on discussing exactly that topic. First, I will provide a basic overview of the Fourth Amendment to the United States Constitution and the warrant requirement. Second, I will discuss the judicially created exceptions to the warrant requirement in the form of warrantless searches. Third, I will discuss the reasonable expectations of privacy that citizens have pursuant to the Fourth Amendment to the United States Constitution. Okay? Much of the information that I'm going to share with you today is based upon my studies of both federal and state law pertaining to search and seizure law during my time in custody as a federal pretrial detainee. I actually spent 32 months in custody, became known as somewhat of a jailhouse lawyer during that time in custody as I litigated my case, and I assisted many other defendants who were incarcerated like me in the defense of their cases. And this is pretty much in layperson's terms, an overview of your rights. Of course, everybody considers that, or a lot of people rather, believe that the Fourth Amendment gives them the right to privacy, and that it's very broad and covers everything except for a few different exceptions. And in practice, the way the courts have determined this is it is the opposite. Essentially, you can form the belief that you do not have an expectation of privacy except in a few exceptions, which I'll discuss. Okay? The Fourth Amendment to the United States Constitution secures your right to be secure from unreasonable searches and seizures, and that no warrant shall issue to search any places, things, or effects without probable cause supported by oath or affirmation and issued by a neutral and detached magistrate. And that warrant requirement is important because it prevents officers from just busting into your home and invading your privacy without probable cause for doing so. Okay? There are remedies for violations of the Fourth Amendment, of course. In criminal cases, there's what's known as the exclusionary rule, and any evidence that is seized or searched for and then seized in violation of your Fourth Amendment rights is excluded from being used against you at trial. And there's also exceptions to that, of course. If you offer testimony and that testimony can be impeached by illegally seized evidence that's not being used against you directly at trial, then that evidence can be introduced to impeach your testimony. And of course, that evidence can also be used at sentencing hearings in determining a sentence that is applicable to your particular case. Okay? Other remedies than the exclusionary rule include, of course, lawsuits. Within the federal realm, there's what's known as the 1983 action that you can file in the federal courts to sue law enforcement officers for violations of not just your Fourth Amendment rights, but many different civil rights. Okay? Now, the judicially created exceptions to the warrant requirement is pretty broad. Basically, the courts have adopted a reasonableness standard, so now it's not a matter of whether or not searches are considered unconstitutional, but rather, are they unreasonable? And only if they're unreasonable will, different lawsuits and exceptions typically apply. Examples of warrantless searches that are reasonable include searches upon your consent, searches incident to arrest. If you're being arrested, they can search an individual, they can search anything immediately around that individual. If the individual is arrested in a home, they can look in other rooms to make sure that there's not someone else present in the home that may pose a danger to officers. Okay? Exigent circumstances, such as hot pursuit. If somebody runs into a house, obviously law enforcement can follow them into that house and can anything they observe that's in plain view, which is an exception I'll get to in a moment, is considered lawful. Of course, if they have any reason to believe that evidence is being destroyed or that will be destroyed, such as they knock on a door and hear sounds consistent with the destruction of evidence, then they can kick in the door without a warrant in order to preserve that evidence. Of course, there is the stop and frisk, which allows officers to stop an individual based upon reasonable suspicion that that person's committing a crime and to frisk them if they feel something in their pocket that they believe may be contraband based on their training and experience. Of course, they can remove it from that individual's pocket. There are automobile exceptions. Of course, if your vehicle is pulled over based on probable cause of you committing a crime or even reasonable suspicion, that your vehicle has been involved in a crime, and then they develop probable cause to believe that evidence may be within the vehicle. They can then search the passenger compartment of the vehicle in addition to any locked containers in the vehicle, such as the glove compartment and trunk, without a warrant. Okay, plain view is probably the broadest exception, and basically that means that anything that a law enforcement officer observes that is evidence of a crime, they can seize, and that search and seizure is considered lawful as long as the officer is lawfully present in the location from which they observed that evidence, and they had a lawful right of access to that evidence based on other exceptions or, of course, warrants, things such as that. Okay. The third thing I'm going to discuss is the reasonable expectations of privacy that citizens have pursuant to the Fourth Amendment based upon, or rather limited by, those judicially created exceptions. Basically, you have a right to privacy inside of your residence. Of course, if anyone can see through doors or windows or hear sounds inside, then that is not covered. That is not considered an expectation of privacy because someone outside the home is able to observe it. You have a limited expectation of privacy in the curtilage immediately surrounding your residence, such as the backyard, side yards, and to a very limited extent the front yard. Private property is pretty well the same as public property. It doesn't matter if you own 100 acres of land. Due to something known as the open fields doctrine, you do not have any reasonable expectation of privacy there. Inside of an automobile, you have a very limited expectation of privacy. And of course, if they develop reasonable suspicion to pull you over, and then develop probable cause that there's evidence of crime within your vehicle, they can search it. And of course, an individual has a very limited reasonable expectation of privacy as well, and that things in your pocket, maybe can't be seen by others. However, if an officer suspects that you're committing a crime, they can frisk you. If they feel something and they can articulate that it may be contraband, they can then seize it. So those are the different exceptions. Of course, I provide the basic overview, the judicially created exceptions, as well as what reasonable expectations of privacy that you have as a citizen. In closing, I would like to offer a quote by Dave Rutger, in which he stated, "The Fourth Amendment wasn't written for people with nothing to hide any more than the First Amendment was written for people with nothing to say." So they are your rights. Definitely utilize them. And for this, to prepare, of course, I reviewed the Bill of Rights as well as a book by H. Morley Swingle entitled Search and Seizure Law in Missouri. I actually have a t-shirt that I had custom designed that contains the text from the Bill of Rights pertaining to several of these different rights, and especially the Fourth Amendment.